believe the issues to be addressed today are property distribution and debt distribution, parenting plan, child support, and fees and costs. So Mr. Geist, do you agree with that, or are there any other issues that you're planning on addressing today?
I believe that's all that we need to go over.
Okay, all right. So we're here today for a trial, and I know that Ms. Looney sometimes will ask to maybe go first and maybe be excused, and I'm not sure what her position is, so I just wanted to touch base with her to see where you're at.
Yes, Your Honor, the state's only interest as to child support in this matter is for medical. So our only request is that it be noted in the final order that the child is on state medical through the mother.
Okay. All right, thank you, Ms. Looney. Ms. Bliss, any comments related to that?
No, Judge, upon seeing Ms. Looney on the call today, I realized that I did not include that in the final child support order, but I have no objection to including that language. Obviously, that is appropriate.
Okay, great. And Mr. Geist, any comments you have related to that?
I'm just curious what expectations are to be held to the situation.
When you say expectations, tell me what you're thinking there.
I have another child and he's on state medical as well, so I'm not quite sure what the disposition of the situation would be.
Ms. Looney, could you just share the state's position, what you're hoping to have added or included in the orders?
Your Honor, we are only asking to just have it noted that the child is receiving state medical. We're not addressing any other children, just the children shared between these two parties. So if Mr. Geist has questions about his other child, he would need to contact DCS about that.
Okay. So,
all right.
Yeah, go ahead, Mr. Geist.
I don't have anything else to say. I wasn't quite sure.
Yeah, and it's fine to clarify and limit. So Ms. Looney, so as far as you're just asking for the orders just to simply make a notation that the child here is being covered by state medical insurance through the mother.
Yes, Your Honor.
Okay. All right. Any questions on that, Mr. Geist? Any further questions?
Just as I previously stated, I didn't know exactly what the concerns or what's to be addressed in the situation. I think that she just verbalized that it's just to be noted and documented.
That's my understanding. And Ms. Looney, is there any fallout from that if it's noted or documented that the child's on state medical?
No, Your Honor, it's just to be sure that the order includes that the child is receiving state medical. That way it is clear in the future that mom is fulfilling her obligation for providing medical insurance, which both parents are obligated to do. It just shows that she is doing that because she does not have other insurance available.
Okay. All right. Thank you. Ms. Bliss, Mr. Geist, any further comments related to the state's position?
I don't have anything further, excuse me, and I don't have any objection to Ms. Looney being excused.
Okay. And Mr. Geist, any further questions or issues?
I believe that matters. Yes, I agree to the situation. I'm not exactly sure what to say.
Okay, yeah, that's fine. Great. All right, Ms. Looney, thank you for being here today. It sounds like there's no opposition to including that language in the order, so that'll happen. And if you want to leave, you're free to do so.
Thank you, Your Honor.
All right. So with regard to the trial today, just a little bit about procedure and expectations. Here, the petitioner is see as Ms. Geist, represented by Ms. Bliss. So generally, the petitioner goes first in the trial, in which they call witnesses to establish a factual basis for what they're asking for. So they'll be calling witnesses, and with each witness that goes that's called, Ms. Bliss will ask the series of questions first, and then Mr. Geist, you'll have an opportunity to ask that same witness questions under cross-examination. And then after you've finished, then Ms. Bliss will have some more opportunities to ask questions of that same witness. And then you would then have an additional opportunity to ask questions of that witness on what they call recross-examination. So it's kind of like a funnel in that the questions start off fairly broad with Ms. Bliss going first and then you going next. And then Ms. Bliss goes their second shot at that witness, so it's a little more narrow. And then the questions that you ask would also be kind of limited to the scope of the questions on that second round of questioning of that particular witness. So with each witness, that once she's called all of her witnesses, then Mr. Geist, you'd be entitled to call your own witnesses, including yourself. If you do call yourself, we just allow you to provide a narrative. You don't have to ask yourself a question and then answer that same question in kind of that stilted manner. We don't do that. And then as far as any exhibits or documentary or documents that you want to have admitted or have the court considered, we should have had those already admitted or at least provided to the clerk. I have some from Ms. Bliss And I just want to touch base with Mr. Geis if you had any documents that you were hoping the court to see or review.
Not necessarily. I've gone over what Ms. Bliss has put together, and I would like to be able to discuss some of it on my opposition to it. Other than that, I don't know. I don't have anything that I would have filed necessarily in the case.
Okay, yeah, you'll certainly have opportunity to question and address those particular documents that Ms. Bliss has provided, and I have a copy of all of them, so I'll be able to look at what you're talking about. And then so then after you've called your witnesses, Mr. Geis, then Ms. Bliss may call what they call rebuttal witnesses, and you would also have opportunity to ask those same witnesses questions. So after everybody's presented their evidence through testimony or documents, then we go to closing argument. That's where each party kind of summarizes their argument based on the facts that are presented and say, this is why I should win and this is why I should get what I want. And then I'll take the case. And if I usually like to take some time to deliberate and reconsider the information that I've heard. And generally, depending on the timeframes, I would come back today and give you an oral decision. If it's going to take a little bit longer, I'll let you know and we'll set a date for me to give you the decision. Then once the oral decision has been given, then a summary of that oral decision would be put into writing, and we would probably set a date for a presentation in the future. Other than that, I'll just turn to the parties to see if you have any preliminary issues that need to be addressed. Ms. Bliss, do you have any preliminary issues?
I do not, Judge. We're ready to proceed.
Okay. Mr. Geis, do you have any preliminary issues before we get started?
I define preliminary issues.
Sure. Sometimes there may be for example, it would be some type of request prior to the trial getting started that may impact the trial. It may be a limitation on some evidence or a request that certain witnesses be taken out of order, or a witness not be allowed to talk about X, Y, or Z, or anything that would kind of affect kind of the future trial or the trial that's about to begin. So anything that may impact that was kind of a preliminary issue.
My only concern throughout this whole process is accusations made against myself being relevant to narcotic use, and there being no factual basis, and then me proving myself innocent in the situation, following that. And is my question is this going to be an ongoing matter where, I've had to prove myself time and time again, and then where's the evidence to the situation kind of a deal?
All right, so it sounds like you're concerned about allegations related to narcotics use made by others, and you're concerned about substantiation of those allegations. And so usually the way we deal with that type of information is that if there's testimony presented, persons can testify to what they've observed or seen or know. If you feel that they don't have a basis for that knowledge, or there's some concern, you can lodge an objection and state why you feel that's objectionable and should not come into evidence. And then I'd rule on that. And if the ruling's in your favor, then that person wouldn't be able to testify of that particular issue or that limited scope. If I rule against your objection, that means that I'd allow the testimony to come in. So oftentimes during trials, there's testimony that comes in that neither side particularly likes and is not necessarily helpful to their case. Sometimes they may object to that on that basis. That's not a valid objection. It has to be on the basis of that there's not personal knowledge of that information. So you're certainly welcome to raise those objections as they come about during the trial, and we can rule on them as we go forward. I think it's going to be context sensitive, so I probably need to hear that information as it comes up during the trial. I don't think I can give a preliminary ruling on that at this point.
All right. Yeah, I just know that when it comes down to these kind of things, unless there's actual proof to a situation, it's more or less a he said, she said, and you can't really, not you personally, but you can't really make a judgment based off of someone said something. What's come down to is a defamation against myself and other people involved, or other people mentioned in the situation.
Yeah, and it's not uncommon in jury or in trials to have he said, she said situations. That's not uncommon. It's very common, and that's where the court makes credibility determinations and weighs the evidence that's presented. So it's not uncommon that there's he said, she said, she said. Pardon me. So with that understanding, I think we'll proceed forward. If there's no other preliminary issues, we'll hear opening statement from Ms. Bliss, then we'll turn the time to Mr. Geis if you'd like to present opening statement, and then we'll turn the time to Ms. Bliss for the calling of her first witness. So Ms. Bliss, opening.
Thank you, Your Honor. I'll keep it brief. The issues before the court today are very minimal. The court is aware I do represent Ms. Geis in this matter, who is the petitioner and moving party. Your Honor kind of outlined the issues being presented today, the issues relating to asset and debt distribution, the parenting plan of young Ezekiel, who you'll hear referred to as Zeke throughout the course of this trial, child support for Zeke, and the issue of attorney's fees. I did provide a trial aid in this matter, and I trust Your Honor has had the opportunity to kind of get an overview, at least of our position. So at this point, I would finish my opening statement with the proposals that we've provided to the court are fair and equitable as it relates to the asset and debt distribution. The parenting plan and child support for Zeke are in his best interest. Attorney's fees, you'll hear testimony from my client today, are warranted in this case, given the significant hurdles that we've had to overcome with Mr. Geis on top of my client paying for this entire matter to be proceeding. So we are asking the court to enter our orders after you hear some testimony today. I'll kind of reserve the rest of any statements or arguments for later in the trial.
Okay, thanks. Mr. Geis, any opening statement you'd like to provide?
I would like to just say that given the circumstances of the divorce, I understand that there's hurt feelings involved, but the person that really matters in all of this is Ezekiel. I understand that the dissolution of her marriage is part of the topic, but another part of the topic is that there's a child involved in the situation, and how he feels really matters in all of this, and I hope the outcome is in his favor.
All right, thank you, Mr. Geis. All right, Ms. Bliss, if you'd like to call your first witness.
Thank you, Your Honor. I'd like to call my client Petitioner. When were you married?
August 31st.
Okay. And was that in 2019?
Yes.
Okay. And when did you and Mr. Geis separate for a final time?
March 12th, 2022.
Okay. And is she coming through? Is her audio coming through?
Kind of. It's fairly clear, but there's some things that were kind of trails off, like that 2020. I wasn't quite sure of the data separation. It wasn't as clear as I'd like it to be.
Okay. I suspected that. So just make sure that you're, obviously my name is right next to it, but make sure you don't know. We just got to make sure that the record is very clear. So will you say again when you and Mr. Geis separated for final time?
March 12th, 2022.
Very good. And what happened on the statement?
The exact day we had a disagreement over a situation that involved Elijah and Jacob and myself with Zeke, and I asked him to leave.
Okay. And we haven't discussed Elijah yet. Who is Elijah?
Elijah's my stepson.
Okay. And that's Mr. Geis's other child.
Yes.
Okay. And so after this incident, you asked Mr. Geis to leave, and then you filed for divorce.
Yes.
Okay. Was Mr. Geis personally served with the petition for divorce?
Yes.
Okay. And was that in August of 2022?
Yes.
Okay. During the course of your marriage with Mr. Geis, you obtained a few assets. Is that fair to say?
Yes.
Okay. So let's talk about that. What vehicle do you drive?
The 2022 Tucson.
Okay. And that was acquired during the marriage?
Yes.
Okay. And what would you say the condition of this vehicle is?
Yeah.
Okay. And do you have a rough guesstimate of what you think this vehicle is worth?
25,000.
Okay. Do you recall?
Just Bliss, Ms. Geis' voice was not terribly clear on the value. I'm wondering if she could maybe change her position, or maybe move closer to the speaker, like shift her chair down a little bit further so I could hear a little better.
There we go. I'll try that again. Thanks, Judge. Can you say again what you believe the rough value of that vehicle is?
25,000.
Okay. Do you recall doing some research on those vehicles and looking at kellybluebook.com?
Me personally?
Or we for purposes of the trial?
Yes, you did.
Okay. And do you recall, I'm going to turn to what's been marked as exhibit number 16 at this point. Do you recall this document being prepared?
Yes.
Okay. And can you provide what that document says for the court?
$27,519.
Okay. And do you think that that's an accurate representation of your vehicle?
Yes.
And does it note that that's your vehicle in the top left-hand corner?
Yes.
Okay. At this point, Your Honor, I move to admit it was been marked as exhibit 16.
Mr. Geis, any objection to the court admitting exhibit 16?
No.
Right. Exhibit 16 is admitted.
Thank you. Natasha, is there a current debt on that vehicle?
Yes,
Okay. And do you recall what the debt of the value of the debt at the date of separation was?
no.
Okay. Okay, if I showed you a document that we provided to the court, which may have that on there with that refreshing recollection.
Yes,
Okay, so I'm handing you what's been marked as exhibit 18. Can you provide a little bit of information on what that document is to the court?
this is the bank statement on the account for when the vehicle's loans through.
Okay, and can you see what the value of the data separation was on that document?
$34,977.32.
Okay, and is that an accurate representation of the account that your vehicle is financed through?
Yes,
Okay, at this time I move to admit 18.
Any objection, Mr. Geis?
No, sir.
Okay, 18 is admitted.
Thank you. Moving on to what Mr. Geis drives. What vehicle does he drive?
I can't remember the year, but it's a Silverado.
Okay.
Chevy truck.
If I told you it's a 2018 Chevy Silverado, does that refresh your recollection?
Yes,
Okay. And when was this vehicle purchased?
I can't remember.
Was
It was
it-
after mine.
Okay, but it was
Or no, it was before mine. Sorry, I had a different car for the Tucson.
that's okay. It was purchased during the marriage though.
Yes,
Okay. And to your knowledge, is that vehicle in good condition?
yes,
And do you recall what the value of that vehicle is?
no,
Do you remember us preparing a Kelly Blue Book on that vehicle for purposes of trial?
yes,
If I showed you that document, would that refresh your recollection?
yes.
Okay, so I'm handing you what's been marked as exhibit 17. Can you describe that document for the court?
It says fair purchase price for a 2018 Silverado is $32,115.
Okay. Do you believe that that's an accurate reflection of Mr. Geis's vehicle?
Yes,
Do you believe that's an accurate reflection of the value of that vehicle?
yes,
Okay, at this time I move to admit 17.
Any objection to the court considering it admitting exhibit 17, Mr. Geis?
No objection.
Okay, 17 is admitted.
Thank you. To your knowledge, Natasha, is there a debt on this vehicle?
yes,
And do you recall what the debt amount of the data separation was?
no,
If I showed you a bank statement, which I believe encompasses that debt, would that refresh your recollection?
yes.
I'm handing you what's been marked as exhibit 19. Can you describe that document for the court?
This is the bank account loan for Jacob's truck. And it says $29,518.54.
Okay, and is it your understanding that that is the account for that truck?
Yes,
And that is the value in the data separation for the loan of that truck?
yes,
Judge, at this time I move to admit 19.
Any objection to 19 being admitted?
No objection.
19 is admitted.
And Natasha, who are you asking the court to award this asset to?
the truck to Jacob.
Okay, and I didn't ask you for the Tucson. Who are you asking the Tucson to award it to?
Me.
Okay, and these are both vehicles that both of you have driven and currently drive?
Yes,
Okay. I want to turn next to some bank accounts that you held during your marriage. What bank account do you currently use?
the fiber.
Okay, and is that the one ending in 922?
Yes,
Okay, and when was this account opened? Was it opened during the marriage?
yes,
Okay, and you had access to this account prior to separation,
yes,
and even after separation, you continued to use this account.
yes,
What funds were used to open this account?
mine.
Okay, and when you say yours, was it from like your paychecks?
Yes,
Okay, and who are you asking to award this account?
me.
Okay, I have provided to the court what's been marked as exhibit 13, and I'm gonna show you that right now. Is that a document from your bank account?
Yes,
And when was the date of that document?
the date, 3/4 to 3/31/2022.
Okay, so this document encompasses the date of separation.
Yes,
Okay, and what was the value of this at the date of separation?
$1,005.24.
Okay, and this is an accurate reflection of that account to the date of separation?
Yes,
Are you, and you're asking the court to award you this account?
yes,
Okay, at this time I move to admit 13.
Any objection?
No.
All right, 13 is admitted.
Do you have any other bank accounts?
besides the loan for the car now.
Okay, and is that loan through Red Canoe?
Yes,
And is that valid, or is that account ending in 27?
yes,
Okay, and this
And
was,
is that for the Tucson, the 27 account?
yes,
Okay, thank you.
Judge. And this account was opened during the marriage,
Yes,
and this account remains open currently.
yes,
Okay. In this account, do you solely use it for the loan for the vehicle?
yes, that's all I use it for.
Okay. You never deposit any money into it or use the savings account or checking account?
No,
And that's been marked as exhibit 14. Can you tell the court what this document is?
this is the loan information and the balance on the Tucson.
Okay, and what is the date of that document?
3/1 to 3/31,
Do you have
2020.
any other bank accounts?
No,
Okay, how about Mr. Geis? Do you know what bank account he has?
and I know as far as he has a red Canoe account, I don't know about anything else.
Okay, and is that the account ending in 746?
I believe so.
Okay, I'm gonna show you what's been marked as exhibit 15. Can you describe this document?
Jacob's bank account at Red Canoe for savings and checkings.
And to your knowledge, was this account open during the marriage?
Yes,
And did you ever have access to this account?
yes,
Okay, did you and Mr. Geis both deposit and withdraw money from this account?
yes,
Who are you asking to be awarded this account?
Jacob.
Okay, and did you indicate the date in which is listed on that document?
3/1 to 3/31, 2022.
Okay, and what is the value as of that document? Or the value of the account? Does it say how much the balance is?
$405.
Okay, and are you asking this be awarded to Mr. Geis?
Yes,
Okay, at this time I move to admit 15.
Any objection?
No objection.
15 is admitted.
Yeah. Do either you or your husband have any retirement accounts, investment accounts, pensions, anything like that?
yes,
Okay, and who has those?
Jacob does.
Okay, and did he acquire this during the marriage?
Yes,
Okay, and where is this account through?
Teamsters?
Okay.
Union?
Okay, and is that from his employment during the time?
Yes,
Okay, I'm gonna look at what's been marked as exhibit 12. Can you describe to the court this document?
the Teamster Pension Trust, and it shows Jacob's plan coverage.
Does it have a value on this account?
Yes,
And what does that say?
$663.84.
Okay, and is there another value next to that number?
It's $3,457.37.
There you go. Is that the value that you believe that account is worth?
Yes,
Okay, and who are you asking this to be awarded to?
Jacob.
Okay, at this time I move to admit 12.
Any objection?
No objection.
12 is admitted.
So aside from some, maybe some personal property, clothing, things like that, but that's pretty much the bulk of your assets that you've acquired during the marriage, is that correct?
Yes,
Okay, and so let's move to some debts. Unfortunately, you both have acquired quite a bit of debt throughout the marriage.
yes,
Okay, so let's kind of go through some of those debts. Did you bring in the Target card when you married?
yes,
Okay, and is that the 8316 Target card?
yes.
Okay, and I'm gonna show you what's been marked as exhibit 28. Can you describe this document for the court?
The summary of account activity for my Target card,
Okay, and what is the date of that statement?
March 27th, 2022 was the closing date on it.
And what was the value of that debt as of the date?
$4,400.26.
And what was this debt used for, or what was this card used for?
At this time, the majority of it was purchases made for Zeke.
Okay, and when you say purchases for Zeke, what kind of purchases?
Clothes, preparing for the arrival of him, and formula, diapers, everything.
Okay, did Mr. Geis have any access to this card?
No,
Okay, but the card was used to buy things for the child that you both share.
yes,
Okay, and who are you asking to be awarded this debt?
me,
At this time, I move to admit 28.
Any
Your husband
objection?
also have a
Okay.
Target red card.
apparently.
Okay, did you ever use this card?
No,
Did you ever have access to this card?
no,
Um, Are you asking that this account be awarded to him?
yes,
Looking to the Red Canoe Visa, ending in 746, do you recall this account?
no,
Okay, do you, after going through discovery and learning of this account, did you learn that this is one of Mr. Geis' cards?
yes.
Okay, I'm gonna show you what's been marked as exhibit 20. Can you describe this document for the court?
Summary of account activities for 3/31/2022,
Okay, and what was the balance owing at that date?
$479.33.
And who are you asking to be awarded this account?
Jacob.
Okay, thank you. And first time I moved to admit 20.
Any objection?
Each account first. Primarily, did you know of this account during your marriage?
No.
You did not know of its existence or that Mr. Geis was using it?
No.
Did you know that there was an outstanding balance on this account during that time?
No.
Okay. I'm handing you with the Marcus Exhibit 23. Can you tell the date of that document for the court?
Statement closing date was 4/9/2022.
Okay. So this was just after your date of separation?
Yes.
Okay. And what was the balance owing at that date?
$567.30.
Okay. And did you obtain this document through discovery?
Yes.
Okay. And who are you asking to award this debt?
Jacob.
This time I moved to admit 23.
Any objection?
No objection.
6-0 account. I'm showing you what's in Marcus Exhibit 24. Similarly, did you know of this account's existence?
No.
And did you also learn this through discovery?
Yes.
And you obtained this document through discovery?
Yes.
And what is the date of this?
So for United States. The statement closing date is 3/26/2022.
Okay. And this was also around the time of your separation.
Yes.
And what was the balance owing as of the statement?
$436.93.
And who are you asking to be awarded this debt? Did you learn of a PayPal account of Mr. Geis's?
Yes.
And how did you learn of this?
Discovery.
Okay. And you did not have any knowledge of this during your marriage?
No.
Did you know what this account was for?
No.
Okay. I'm handing you what's been marked as Exhibit 25. Can you describe to the court that document?
Statement closing date 3/25/2022. PayPal credit card account.
Okay. And what was the balance owing as of this date?
$79.77.
And who are you asking to be awarded this debt?
Jacob.
Now, Natasha, we had provided a balance sheet to the court that kind of just outlined the various assets and debts and who you propose they be awarded to. Is that right?
Yes.
Okay. And all of the assets and debts that we just spoke about are included on that balance sheet.
Yes.
Okay, thank you. And do you believe that this is a fair distribution of both the assets and the debts?
Yes.
Do you acknowledge that even though on the balance sheet you're taking on substantially more debt than Mr. Geis, you're still asking the court adopt your proposal?
Yes.
Okay. Let's talk about your income. What do you do for work?
I'm home carried.
Okay, and
I didn't hear the answer very clearly. I apologize.
say again.
I'm a home carried.
A home carry. Okay.
Thank you.
Yes. And do you get paid hourly, salary? Hourly. And what do you make per hour?
I'm not sure. I'm sorry.
That's okay. Did we provide pay stubs for the court to consider today?
Yes.
If I handed you those, would that refresh your recollection?
Yes.
Okay, I'm handing you what's been marked as Exhibit 2. And what are those documents?
My pay stubs.
Okay. And are those an accurate reflection of your pay stubs?
Yes.
And to your knowledge, they haven't been altered or modified?
No.
Okay. And on that document, how much does it say you make per hour?
$22.59.
Okay. And do you foresee any raises in the future or any bonuses in the future?
Yes.
Okay. And do you have any idea as to when those will occur?
My union fought for every 6 months we get a raise.
Okay. And when is that 6-month period going to occur? Do you know?
I don't.
Okay. But as of right now, this is an accurate reflection of your wages.
Yes.
Okay. I move to admit Exhibit 2.
Any objection?
No objection.
2 is admitted.
And it looks like with your pay stubs, you roughly earn about $2,700 per month. Is that fair to say?
Yes.
Okay. And this is pretty standard for your typical income?
Yes.
Okay. I want to show you what's been marked as Exhibit 1 for you to tell the court what this document is.
Tax return 2022. This was mine.
Okay. And did you file jointly or separately for this year? The 2022 year?
Separately.
Okay. And what was your year-end income as of 2022?
$31,470.
And is this an accurate reflection of your tax return that year?
Yes.
And to your knowledge, nothing's been altered or modified?
No.
At this time, I move to admit Exhibit 1.
Any objection?
No objection.
1 is admitted.
For purposes of child support, are you asking the court to use your actual net income, that $2,700 figure that we just spoke of?
I do believe so. Yes.
Okay. And you believe that that's an accurate reflection of your current income?
Yes.
Okay. And what are you asking the court to do for Mr. Geis's income?
To use the income that he was making when we first separated.
Okay.
While we were still married.
Okay, let's talk about that. So you're asking the court to impute him in a different income than what he's currently making, and why is that?
I feel that he quit his better paying job on purpose to lower his child support obligation.
Okay, and we've provided some documentation to the court that we'll discuss a little bit later regarding his various jobs that he's had over the course of this case. Is that correct?
Yes.
Okay. So for purposes of our child support worksheet, we're asking the court to use an income of roughly $4,200 per month for him. Does that sound about right?
Yes.
Okay. Does Mr. Geis have any other children that he's required to support?
Yes.
And is that Elijah that we spoke of earlier?
Yes.
To your knowledge, is he paying child support for Elijah?
Yes.
Okay. With that understanding, are you asking the court to award him a whole family deviation?
Yes.
Okay. With that deviation and with those income calculations, are you asking the court to order him to pay child support in the amount of $523.58?
Yes.
For purposes of the tax exemption and claiming Zeke, are you asking the court to award you the tax exemption every year?
Yes.
And why are you asking that?
Because Zeke's primarily in my care.
So we'll get to visitation in a moment, but the majority of the time, Zeke is in your care. Do you have any extra expenses that you're not able to cover with the monthly child support?
Yes.
And what are those expenses?
Childcare.
Okay, so childcare is an issue. Is any medical expenses for Zeke an issue?
No, not at this time.
Okay, and that's because he's on state insurance?
Yes.
Okay, so there's some daycare expenses, obviously his day-to-day needs, and you don't believe that the current child support or the child support that would be entered would be enough to furnish those fees?
Yeah.
Okay, and you believe that a tax exemption should be awarded to you every year because of that?
Yes.
Okay. I want to turn to the issue of attorney's fees. You've paid quite a bit to have me as your counsel, is that correct?
Yes.
Okay, and we provided a fee affidavit to the court that kind of encompassed all of the fees that you paid me. Do you recall that?
Yes.
Okay, and do you recall roughly how much you've paid me as of today?
Over 10,000?
Okay, did we estimate after today's date that you'd owe me about $12,000?
13.
13, there we go, okay. And did you make attempts to resolve this case during the lifetime of the case?
Yes.
Okay. Did we attempt a settlement conference?
Yes.
Did Mr. Geis attend that settlement conference?
No.
To your knowledge, was he forthcoming with discovery?
No.
To your knowledge, has he attempted to resolve this case at any time in this case?
No.
So is it your position that you filed the case and getting it to finalization was on how we're doing?
Yes.
Okay. Are you asking the court to order a contribution towards your attorney's fees?
Yes.
And what are you asking the court to award?
10,000.
Okay. And you believe that this is fair given the behavior of Mr. Geis throughout this case?
Yes.
Okay. I want to turn to the most important part of this case. That's Zeke.
Yes.
Can you tell the court how old Zeke is?
He just turned 2 in October.
Okay. So 2-year-old, a toddler. Is he walking?
Yes.
Does he have the toddler hunger growing pains?
Yes.
Yes. Okay. So let's talk about since Zeke has been born, kind of what your role in his life has been.
I do everything. I take care of him. I was on maternity leave and I did everything by myself. Sorry. I did all the feedings, all the changings. I was lucky if I got a diaper change out of Jacob when he would come home from work. He wouldn't let me take a shower. If I asked him, I had to ask him for permission to even take a shower during my maternity leave. I would have friends and family come over to help me a little bit, and just so I could try to so I'm home carried and I take care of an elderly lady, and of course she went without when I was on maternity leave, but I felt bad, so then I had a family member come over and watch Zeke for me so I could go check on her. And Jacob wouldn't even watch Zeke at that point. He would be sleeping in the bedroom during the first 4 months that we were still together after I had Zeke. Now I have a friend taking care of Zeke that's been there since he was about 5.5 months old, and she does really good at taking care of Zeke for me. I'm not sure if that makes any sense, but I pay all the bills and stuff by myself. She helps me out a lot, and then it's just me and him in the evenings and the mornings when I'm not at work. So
Okay, that's good. So while you've cared for Zeke, do you play with him?
Yes,
Do you provide him, teachings and guidance?
yes,
Unfortunately, sometimes you have to be a disciplinarian too, is that correct?
Yes.
Okay. Is he, so he's only 2, he has a daycare provider currently.
yes.
Are there other children in that daycare?
No, he
Okay.
gets taken care of at my house.
Okay. Do you provide him social interactions?
Yes,
To the extent of raising Zeke, who primarily does that?
I do.
And you kind of touched on during your relationship while you and Mr. Geis were still residing together, kind of what his involvement was. Was that the extent of his involvement?
Yeah, it was very minimal.
Okay. So you indicated that getting to change diapers was difficult.
Yes,
Watching him while you took a shower or went to work was difficult.
yes, or even feeding in a bottle.
So his primary caregiving was by you,
Yes,
and that's continued even after separation.
yes.
Okay. Let's talk about your bond with Zeke. Do you have a strong bond with Zeke?
Yes.
Okay, and how would you describe that?
I didn't realize how much I could love someone until I had him. Sorry.
It's okay.
It's very strong. I mean, I would do anything for him.
And how would you describe Zeke's relationship with Mr. Geis?
I have no idea.
Okay. Have you spent much time interacting or watching the two of them interact since you've separated?
No.
Okay. Let's talk about Zeke's medical appointments. Historically, have you made those appointments?
Yes.
Have you attended those appointments?
Yes.
Would you say all of those appointments?
Yes.
Okay. And to your knowledge, how often has Mr. Geis attended those appointments?
He's only attended one.
Okay. And what was that appointment? Do you recall?
It was a doctor's appointment,
Okay.
just for a checkup, and he got a shot.
Okay. So since Zeke has been born, you've attended every doctor's appointment.
Yes.
Does he go to the dentist?
Yes.
And do you attend those appointments?
Yes.
Has Mr. Geis attended those appointments?
No.
Okay. Has there ever been a time where Zeke has needed emergency medical care?
Yes.
And have you tended to those needs?
Yes.
Have Mr. Geis?
No.
Let's talk about that. So what was the incident where Zeke needed some emergency medical care?
Well, I thought he needed emergency medical care. He fell off of his dresser and he stood up for a second. He has a bookshelf above his dresser that he was reaching for, and his changing table's on top of his dresser, so that's why he was on top of it. And I turned my back for a second and he fell off. And when I picked him up, I noticed that his face was pretty smashed in. It wasn't bleeding or anything, but I was scared that he needed to go to the emergency room, so I took him. At the time, I could not get a hold. Jacob has me blocked on his phone. My babysitter came with me because we were getting ready for bed, so she actually turned around and came back over to the house to come with me to the emergency room. And she called Jacob from her phone, and Jacob hung up on her. And then he proceeded to tell me that I would have to tell him everything that was going on through text, and he refused to come to the emergency room.
And when this incident happened, was the emergency room close to Mr. Geis's home?
Yeah, not like 5 minutes, if that, away from his apartment.
Okay. So even under a pretty scary situation where you had to take your child to an emergency room, Mr. Geis didn't attend?
No.
Okay. You indicated Mr. Geis has you blocked on his phone?
Yes.
Is that correct? Okay. So you're unable to call him
Yes.
or text him?
Yes.
In the event of any sort of emergency or major issue, you can not get a hold of him?
Yes.
Okay. How do you communicate with Mr. Geis currently?
Email.
Okay. And is that sustainable in emergency situations?
No, that's why I use my babysitter's phone.
Okay. Okay. So I want to talk about our proposed parenting plan. You're asking for the court to make some limiting factors under that section 3 area. Do you recall that?
Yes.
And has the court already made findings under this section?
Yes.
Okay. Primarily regarding neglect? Is that
Yes.
correct? Okay. And is that, we kind of covered it just recently about Mr. Geis having minimal involvement in Zeke's care and caregiving. Is that why you're asking the court to make this finding?
Yes.
Okay. Did Mr. Geis have any issues with alcohol or substances during the relationship?
Yes.
And can you provide the court a little snapshot of what that looked like?
So while I was pregnant, Jacob started drinking very heavily, and one of the worst incidents I remember was 4th of July. He had ended up drinking a 5th of peanut butter whiskey, and he proceeded to, after he drank that 5th by himself, he proceeded to mix energy drinks with tequila. And at the time we were with family, his family specifically, and he had gotten so incoherent to the point where he was falling, he couldn't stand, couldn't walk, he could barely talk. And I had to leave him at his uncle's house because I was pregnant and I wasn't going to carry him home. And yeah, he ended up falling on his face, busting his lip open, his nose was swollen. It was not a good situation.
Okay. So that was one occurrence. Were there other occurrences during your relationship with him where you observed him having an alcohol problem?
Yes, several.
Okay. And even after separation, did you still have concerns regarding his alcohol use?
Yes.
Okay. Did you ask the court to order in a previous hearing a alcohol evaluation?
Yes.
And to your knowledge, was that completed?
Yes.
To your knowledge, was Mr. Geis recommended treatment?
No.
And to your knowledge, why was he not recommended any treatment?
He was sober at the time.
Okay. Within that evaluation, was he labeled high risk for relapse?
Yes.
And is that why you're asking for limitations regarding alcohol and drug use during his time with Zeke?
Yes.
Now, we say drug use. Do you have concerns regarding Mr. Geis using drugs?
I do. So, I mean, I don't want to, but I can't trust what he says
And why do you have those concerns?
because he's had a history of using drugs in the past.
He has, okay. And have there been discussions regarding drug use within his home?
Yes.
And is it your understanding that he is residing with no drug users?
He was.
Okay.
So it's the situation, he told me that he was staying with his mom during the week to be closer to work because she lived in Vancouver and he works in Battleground. And so during the week, he was staying in Vancouver with his mom instead of his Longview residence here in town.
Okay. And to your knowledge, were there drug users in his mother's home?
Yes, and he told me that himself.
Okay. Did he say what types of drugs they were using?
They're using coke.
Cocaine?
Yes.
Okay. No, you're fine. And to your knowledge, does Mr. Geis have a history of cocaine use?
Yes. When we first got together, he was trying to use cocaine with his neighbor, and I told him if that was going to happen, then I didn't want to be with him.
Okay. To your knowledge, was there any other drug use during your relationship?
Marijuana.
Okay. And has Mr. Geis been open with the court that he continues to use marijuana?
Yes.
Okay. Do you have concerns about his marijuana usage when Zeke is in his care?
Yes.
And why was that?
When he used it previously in our relationship, it was just he would use so much, like there was no control of it. He couldn't. I mean, it was bad.
Okay. Do you believe that when he's using marijuana that he is able to adequately care for two?
No.
Okay. Is that why you're also asking for those limitations in your parenting plan, prohibiting him from using while or prior to his time with Zeke?
Yes.
Okay. We spoke a little bit about kind of the roles in decision-making for Zeke. So when he gets immunized, who makes those decisions?
I do.
When he needs a doctor's appointment, who makes those appointments?
I do.
If he were to need emergency medical care, who would take him to the hospital?
I would.
If he needed to have, some sort of medical procedure, who would make that decision?
I would.
At any point, has Mr. Geis shown any interest in making any of those decisions?
No.
Are you asking the court to order sole decision-making to you with regards to his medical and schooling decision-making?
Yes.
And is that largely what you've been doing already?
Yes.
Okay. What's the current visitation schedule between Zeke and Mr. Geis?
He gets 1 8-hour visit a week, rotating Saturday and Sundays.
Okay. So if we were to kind of break that down a little bit, he'll get 8 hours on Saturday and then the following Sunday or the next week?
The next
Sunday. Okay. So 1 8-hour visit per week.
Yes.
Okay. And how long has this been occurring?
Since the temporary orders were in place.
Okay. And has Mr. Geis consistently exercised his visitation?
Yes.
Okay. Have there been times that Mr. Geis hasn't exercised visitation?
Yes.
And why is that to your knowledge?
He had to work.
To your knowledge, does he typically work weekends?
Yes.
Okay. Has he ever asked to switch days?
Yes.
Okay. And what have been the circumstances surrounding that?
The switching days because he wanted to work.
Okay. So you said he wanted to work, so he didn't have to work. He's simply choosing to work?
Yes.
Okay. And we've discussed Elijah, his other child. Do you have any understanding of what his visitation is with that child?
He currently does not have visitation at this time.
Okay. Historically, did he have, Elijah and Zeke on the same schedule?
Yes.
And were there any concerns with that schedule?
Yes.
And what were your concerns with that?
My concerns is Elijah and Ezekiel being left unsupervised together.
And did Mr. Geis tell you himself that he had left them unsupervised together?
No.
Okay. Did Elijah's mother tell you this?
Yes.
Okay. To your knowledge, how old is Elijah?
8.
Okay, so it's your understanding that an 8-year-old and a 2-year-old have been left alone?
Yes,
Okay, and that's when when they are in Mr. Geis's care?
yes.
Okay. Do you have any concerns with the current residential schedule?
So not the current, no.
Okay. Do you have concerns with expanding beyond the current schedule?
Yes,
And what are those concerns?
that Elijah and Ezekiel will have to share a bedroom at night, and that they will be left unsupervised together at night.
Why are you concerned about Elijah and Ezekiel being left alone, unsupervised, either tonight or anytime?
Elijah has a history of animal abuse, and he has been in extensive therapy in the past, and he's currently in therapy. So he has some issues that he's working on.
And during your relationship with Mr. Geis, did you personally observe some concerning behavior with Elijah?
Yes, on several occasions.
Okay. During the few months essentially that Ezekiel and you and Elijah and Mr. Geis all resided together, did Elijah behave inappropriately towards Ezekiel?
Yes.
And what were the situations regarding that?
He would get very upset if Jacob would show any attention to Zeke. He didn't want to share a space with him. He wouldn't want Zeke to stare at him even. He would just get upset.
Okay. And is this, so obviously there's, some sibling rivalry or the introduction of a new child, usually there's a learning curve. Do you believe that that's what it was, or do you believe it was something more than that?
I want to say like Jacob probably had something to do with it too, because of the way that I feel Zeke was being treated by Jacob. And yeah, I don't know.
Okay, so if the schedule were to expand beyond what it is currently, would you ask the court to prohibit them being left alone together?
Yes.
Okay, are you open to expanded visitation somewhere down the line when Ezekiel's a little bit older?
Yes.
Okay, why are you concerned with him having extensive time now when Ezekiel is 2 years old?
I'm concerned because Zeke can't tell me what's going on. So I'd like to wait until at least he can say, if something's happening.
Okay, because you do have concerns of what occurs in Dad's household.
Yes.
Okay, so arguably when Zeke is old enough to, voice any concerns, you would not be opposed to expanding visitation?
No.
Okay, also presuming Mr. Geis remains sober and has those alcohol and marijuana prohibitions in place?
Yes.
Okay. Lastly, do you believe that schedule that we proposed and kind of what we've just outlined is in Ezekiel's best interest?
Yes.
To furnish, him growing up and being a productive kiddo member of society?
Yes.
Judge, at this time I have no further questions.
Okay, thank you. Mr. Geis, cross-examination, any questions you'd like to pose?
Yes, I would like to ask questions.
Okay, go ahead.
Miss Natasha, do you recall that when I was presiding at the house, that I was also working a 12-hour shift, graveyard shift, with 1 hour drive each way during the time that was stated that I was just sleeping during the day? Because that time that I was sleeping was the only time I was at home for between shifts.
Ask me a question.
Okay, so Mr. Geis, if you could phrase the question and pose the question, please.
Is it to your recollection that I worked 12-hour graveyard shifts, and the time that I was at home, I was sleeping because that was my only time that I could sleep?
No, I don't remember.
Okay. Is it to your recollection that childcare is currently taken out of my paychecks?
Yes.
Is it to your recollection that I have previously stated that I cannot afford to take time off of work, and that it's not logical for both parents to take the time off of work to attend doctor visits if they're non-emergical?
Yes.
Is it to your acknowledgement that I had stated that I was not staying with my mom in Vancouver for that week period of time, that I was staying with my grandma Ramona?
You told me you were staying with your mother.
Okay.
And your mom told me that your grandma refused for you to stay at her house.
Okay. It was even over text messages and emails stated that I got what I wanted by moving out of the house. Do you recall that I attempted to move out of the home 3 different occasions?
No.
I have no further questions.
Okay, redirect.
Just one question. Natasha, is Mr. Geis current in his child support obligation?
No.
And to your knowledge, how much is he currently owed?
Over 3,600.
I didn't hear the figure. Can you repeat that?
3,600 over.
3,600.
Yes.
Thank you.
So he owes $3,600, and to your knowledge, that's for child support arrears.
Yes.
To your knowledge, does he also have daycare arrears owing?
I had to turn the daycare arrears into DCS because Jacob refused to pay them.
Okay, so DCS is now garnishing his wages for daycare expenses as well.
Yes.
To your knowledge, is he current in those expenses?
No.
So there's outstanding expenses for those as well.
Well, it's all together on the DCS. Whatever he owes DCS is what he owes for childcare.
Okay, so that $3,600 is essentially child support, childcare, all arrearages.
All of it.
Okay, very good. I have nothing further.
Any cross-examination on that issue, Mr. Geis?
I apologize. I didn't take any notes to ask cross-examination, so no, not at this time.
Okay. All right. Thank you. All right. That concludes the testimony of Ms. Geis. Ms. Bliss, would you like to call your next witness?
That is my sole witness, Your Honor, so this time we would rest.
Okay. All right. And Mr. Geis, the time is yours to call witnesses, including yourself.
Judge, I don't mean to speak out of turn. Is there a way that we can take a brief 5-minute restroom break?
Sure. Yeah,
Yeah.
it's 10:11 now, so let's plan on coming back at 10:26. We'll come back at 10:26 and resume things. Go right ahead, please.
All right. So do I ask myself questions or do I just...
You can just go ahead and just tell your story, tell your narrative.
Okay, so at the time upon me leaving the home that me and Natasha shared, there was a lot of disagreements amongst each other, and had primarily to do with my son Elijah, and that there was a disagreement upon him being new to not only being the only child, and so because I did have him as my only child, I did give him all of my attention, and then it was expressed to me that during, that I wouldn't ever be as fond or love Ezekiel the same way as I do Elijah, which isn't fair to say because I can love them both equivalently, but separately at the same time. So at one point in time, I can't recall exactly what this situation was. Me and Natasha had gotten to an argument, and I had tried to evade the conflict, and it was resulting in backlash on Elijah to the point where I was uncomfortable with the situation, and I had, in 3 different occasions, I had packed my bags and said I was going to move out. Each time that was the case, I was always contacted that she wanted me to come back to the house, in which I did, except for the last time I had to make a decision that this revolving door needed to come to an end. And so at that point in time, I had to make this decision based upon how it was affecting my child, and I couldn't put my personal feelings in the situation, how I felt about Natasha. So I even have, though I didn't submit it, I have documentation stating that I am the one that asked for this in the first place, and that I'm getting what I want. I feel that was probably valuable information for me to present, which I didn't take the opportunity to do that. As far as when I was in the home with Natasha, and she had stated that I was sleeping and not giving the child care and such along those lines. I was working a graveyard shift. I was working 12 hours a day, and I was working in Vancouver. So from Longview to Vancouver is 45 minutes, and I was having to drive. So that accumulatively is about 14 hours a day. And so when I'd come home, I'd spend an hour with them and before I'd go to bed. And then in the morning time, or my morning time, I'd spend a little bit of time with them amongst getting ready to go to work and then go to work. And so there was no at-home time really during my working shifts. The days that I had off, I had to also adjust my schedule to meet the schedule of a normal life. And and upon that, I was also having the care of my son Elijah. Um, I don't know how to further elaborate that whole concept of that situation, is because it was complex given the circumstances, and I never was abandonment to any of my children. Uh, there, as along the lines of her feeling like that she didn't have help. The days that I was working, I wasn't able to help her. I admit to that. But the days that I wasn't working, I always put forth my most effort to the situation. And so I can't say that she didn't struggle, because I know that she did. And it's unfortunate, but the circumstances weren't providing. And so upon this is a different matter. Has to do with the child care and what's back owing, and what was stated is that I was refusing to pay child care at the time that this was a circumstance. It's not accurate to say that I was refusing to pay it, but I couldn't afford it, because when I worked at Great Western Malting, I made $25.51 an hour, and I couldn't afford the drive back and forth. And so upon that, I had previously worked for a gentleman up in Longview area, and he said he'd get me a job so that way I didn't have to travel so much. The job that I retained at that time was $24 an hour. And so both, I couldn't afford the drive to make it to Great Western in Vancouver. And then when I got the job up in Longview, which I was barely able to make it at that point in time, based off of now I'm paying more money in child support, and I'm happening to cover more of financial responsibility because it's not a shared income household at this point in time, having to move into a new home and such. At this time, childcare is currently taken out, and it was kind of enforced, but at the same time, that's not exactly the case, because I had just recently achieved getting this job that I'm working at this current time, which is it's more sustainable work. It's better pay. Me making $30 an hour makes a huge difference. I'm working in Battleground, Washington, which is still a 45-minute drive, but that $5 an hour difference really makes or breaks the situation. So that being said, I understand that at a point in time, I was in a financial disposition where I couldn't afford to meet the needs, and it's not Natasha's responsibility. I do accept responsibility in the matter, but I also know that I had to decide whether or not I could pay my rent or my truck payment to be able to make it work, because I don't have another vehicle, or to try to push further on, unfortunately, putting myself behind and putting Natasha in a situation. So at this point in time, I put all my communication with Natasha over email, which may not sound super appropriate, but when we were having telephone communication and she would call me repetitively to yell at me about things, it got to the point where I didn't want this to go undocumented. And so I tried stating to her that maybe we need to go do this over email, or over the court has a communication app that they provide, that so that way the court can analyze it. And that was a communication that the court option was an option, but it was also stated that I was to cover the cost of all of it, and I could not afford to cover the cost of all of it. And so it resulted in just emails between us. Because during that time that Ezekiel ended up going to the emergency room, I answered the phone and I was yelled at And it's not the first time that it's been the case. And I don't respond to that style of communication very well, or I just shut down and I feel belittled and I have a hard time with it. And so it did result in us texting back and forth during that point in time with the child care person. I don't agree with how it was stated that I have a history of drug use, which I don't. Even in my drug and alcohol evaluation, drug use wasn't a concern. It wasn't that documented that they felt like that I needed to um, have that I had a history or they need to have observation based off of the situation. Um, it was stated that I used marijuana. I did use marijuana with Natasha in the home, amongst with her family as well. Everybody, it was an open view on the use. It wasn't that um, there was no opposition to using marijuana, and I don't feel like that I at any point put myself or anybody else in jeopardy during the time of my use of marijuana, which I do not use at this current time. On the regard of Elijah and concerns about him and Ezekiel um, in my care at the same time, Elijah is 8, and he has never shown any eminent concerns in my care to himself, others, or Ezekiel. He is a child and he has lashed out before, never in a manner that where I felt concerned for anybody, including Ezekiel. There has been verbal communication that Elijah has caused harm to animals, but in my personal experience, the only thing that I have witnessed myself is that he grabbed a dog by the tail multiple times, but he was also 6 at that time, or younger than 6. He was 6 years old when me and Natasha separated. So I don't have anything to say about that behavior necessarily because he was a child and his behavior, I feel like, is not um, a threatening demeanor. So at this time, I'd like the opportunity to have more time with Ezekiel. It's unfortunate that things have unfolded the way that they have because um, right out the gate, I was presented to be this um, heinous individual, and without any ability to look into the past or to see what the situation really was, decisions were made based off of we're going to take a greater concern and than to just in case. And so if I was granted more time with Ezekiel, I would be grateful for it. And I've also stated if it was necessary that I take Ezekiel to the doctors. I previously had said that it's, from my perspective, not logical for both parents to take time off of work to go to a doctor's visit. An emergency situation is a whole different story, but to go to a standardized doctor visit, it's not necessary for both parties to take leave from their work, losing that money. Now, if it was necessary that which this is a situation that came up, if it was necessary that I take time off of work so that way she could work, I'd gladly take time off of work so that way she could work. But what it's come down to in the past is that it was requested that I take time off of work for me to go to the doctor's appointment, but she also was going to take time off of work for her to go to the doctor's appointment with me as well. I just didn't find that 100% necessary. If she was already planning on attending the doctor's appointment, why I needed to take the time out of my day to go work. I mean, take my time out of the day to go to the doctor's appointment when that's money lost, especially when I'm already in the current debt situation that I'm in. And my current financial disposition also reflects the reason why I don't have an attorney in this situation and how I I don't necessarily even find myself responsible for her financial obligation to an attorney because she decided the decision for herself, and that I decided the decision for myself because I knew that I wasn't able to afford an attorney in the situation. There's no viable credit to me having any drug or alcohol dependency issues. On the record, January 18th of 2018, I did sustain a DUI, but upon sustaining the DUI, I checked myself into a treatment facility, had an evaluation done. I did 2 years of treatment. This was not court ordered. This was all on my own to meet the needs of a deferred prosecution, which I currently have held my end on all of responsibilities and have tried to I've tried to be an upstanding citizen since that point in time, not putting myself or anybody else in any jeopardy. I understand that at that time I made a mistake, and that at this current point in my life, I would like to move forward and the past not be a reflection of who I am today. I also would like it to be on the record that I have never left Elijah and Ezekiel alone in my care. I've been with both of the children at all times when they're in my care. I only at one point did I leave Elijah home to go pick somebody up and drop them off. And Elijah was 8 years old and has a cell phone and had all of his amenities that he needed. I've even checked in with him during the time that I was absent from the home, which I did not have Ezekiel in my care at that time. I don't feel like that I did anything jeopardizing Elijah's safety or putting him in any harm during this time. If I felt like that any of these were a possibility, that I would not have went and picked somebody up and dropped them off. So I understand that there's perspective on the situation, but I also know that as a parent, that if there was an opportunity for there to cause harm or anything out of the situation that would negatively impact Elijah, that I wouldn't have taken that step. The bigger picture, in my opinion, of this whole situation is that is Ezekiel, and that at this point in time, I am getting him every weekend, one day for an 8-hour visit every weekend. But upon that, I'm also not able to keep a schedule with him because it's a change of environment, and that change of environment, it's not something that he's regular to. And so previously to the hair follicle test that was requested of me, I was able to have him on a schedule. We were doing, me and Natasha both agreed to, every other weekend I was getting in for 8 hours on Saturday and 8 hours on Sunday. And upon that schedule, I was able to keep him in a certain routine, and things were working out. But since then, I've had him for 2 weekends, and I was notified and expressed to that I'm not thinking about Ezekiel's best interest because I wasn't able to get him to go down for a nap. Now, if I put him down and he's upset and it's been over 5 minutes, I'm going to go pick him up and I'm going to let him continue to go about his day. And I'm not going to enforce him to sit there and scream because he's upset that he's not tired, because the change of environment impacts him. I'd like to, moving forward, be able to get into a more regular schedule with him. I would also appreciate being able to have overnights with him as well, because I agree upon the foundation of his development in the regard. You know, I'm not necessarily a stranger, but I'm not consistent in his life. And the more time that I get to spend with him, the better it is for his development. It's been in the paperwork previously that I also am not going to be receiving child care or child tax credits for Ezekiel, which I don't quite understand how that abides, because the circumstances are is that I do provide for the child when I have him, and I do provide child care and child um, um, goodness, child support. And so all things included, my contributions are there. I'm not an absent father in his life. I do feel it's important that um, that I'm viewed as a parent and as responsible as much as the opportunity is given parent to Ezekiel, and that I don't feel like it's fair to be looked down upon based off of allegations that were made without there being anything credible behind all of this. I understand that there may be situations out there in the world, but those situations don't abide to me, and so there's reflection being taken place based off of, this is something that's happened before, not with myself, but this is something that's happened before, and so we're going to take a similar direction as how it's been handled in the past. Yeah, I am currently doing the best that I can for myself and for my children. The world isn't easy nowadays, but I just hope to make improvements to where my children and I are taken care of and provided for the best opportunity I can give them. I don't think I have anything further to say.
All right, thank you, Mr. Geis. Ms. Bliss may have some questions for your cross-examination.
Thank you, Judge. Yes, just a few. Mr. Geis, you indicated that prior to this dissolution proceeding, you had previously worked for Great Western Malting, is that correct?
Yes.
Okay. And that job was in Vancouver?
Yes.
And you indicated that you can no longer work at that employment because of the drive, right?
I couldn't afford the drive.
Okay. And you're currently working in Battleground?
Yes.
Isn't that roughly the same amount of time and distance as your prior employment?
I currently make $5 an hour more than I was making when I worked at Great Western Malting.
Okay, my question was is the distance the same arguably now as it was in Vancouver?
The circumstances are not the same.
Okay, but the fact of the matter is you left Great Western Malting shortly after this proceeding began and drastically reduced your wages. Is that correct?
Can you say that again, please?
Yes. Shortly after this matter began, so when my client filed for divorce, you stopped your employment at Great Western Malting and took a job earning significantly less money. Is that correct?
I had to take the opportunity based off of the current circumstances.
Okay. I want to look. Do you have my exhibits in front of you currently?
What would you like me to look up?
What's been marked as exhibit number 4. And you've provided me this document through discovery, is that correct?
I believe so.
And it looks like in 2022, your year-end income was $72,557. Does that sound accurate?
Sounds accurate.
Do you believe that this document is an accurate reflection of your wages for 2022?
I believe so.
Judge, at this time, I'm going to admit exhibit 4. Thank you. So Jacob, or Mr. Geis, excuse me, you had previously earned significant wages at Great Western Malting, and then you left that job to be essentially a maintenance man for the Office 842. Is that correct?
That's correct.
Yeah. And I have provided an exhibit number 8. Looks like all of your pay stubs from Office 842. Do you have that exhibit in front of you?
I have this in front of me.
And do these look like your pay stubs from your employment at 842?
These look like pay stubs from my employment at 842.
Judge, at this time, I move to admit what the marked as Exhibit 8. So, Mr. Geist, you left employment at Great Western Malting, earning roughly $72,000 per year. And with your employment with Office 842, it appears largely your income was essentially cut in half. You were earning $33,000 as of the date of this statement. Does that sound accurate?
Sounds accurate.
And your reasoning for that isn't that you were going through a divorce with my client, but because of the distance of the employment.
Correct.
You're currently working for Apex Mechanical.
Correct.
And what I have marked as Exhibit 5 appears to be a letter from your employer. Do you have that document in front of you?
Yes.
And in that document, looks like Tabitha Marsh with Human Resources indicates that you're earning $30 per hour with this employment. Is that correct?
Yes.
Okay, and it also says that you're eligible for medical benefits, dental, vision, 401k, but you're not participating. Does that sound right?
Correct.
And are you aware that I had to subpoena these records?
Say that again.
Are you aware that I had to subpoena these records?
I understand that they were subpoenaed.
Okay, you did not provide me these records, correct?
Understood.
Okay. Judge, at this time I move to admit Exhibit 5. Looking to Exhibit 6, Mr. Geist, do these appear to be your pay stubs at your current employment at Apex Mechanical?
Okay.
Do these look like your pay stubs?
I believe so.
And within these pay stubs, it now indicates you're earning $40 per hour. Is that correct?
Can you please say that again?
Are you still earning $30 per hour, or did you get a raise?
I'm still making $30 an hour.
Okay. Judge, I move to admit Exhibit 6. You heard testimony from my client that you are roughly $3,600 in arrears in child support and child care. Do you acknowledge these arrears?
I do acknowledge them.
And that my client made various requests to have you pay child care prior to utilizing DCS services. Is that also correct?
It's correct based off of the fact that I told her that I could only afford what I could afford at the time.
Okay. And now that DCS is garnishing your wages, you are paying child support and child care. Is that correct?
It's correct that the DCS enforcement has taken place since I've gotten a change of employment.
You acknowledge the fact that you only communicate with my client via email.
I didn't hear the last part of that.
You only communicate with my client via email. Is that correct?
That's correct.
Okay. Do you have her blocked, or her phone number blocked, or her social media blocked?
I only have the phone number situation blocked. She has me blocked over social media.
Okay. So if there was an emergency while Zeke is in my client's care, she would not be able to call you.
She has reached out to me in an emergency situation.
Okay, let's talk about that. In your testimony, you indicated that you didn't believe that it was financially logical or feasible for both parents to attend medical appointments, but you specifically said an emergency situation would be a different story. Do you recall that testimony?
I recall that.
Okay, you heard testimony from my client that there was an emergency situation, that you were called out from the emergency room and you declined to come to the emergency room. Is that correct?
The circumstances were that I was going to go, but the thing was is that I was getting scrutinized based off of the situation. And so my attendance turned into lacking because of the situation. I asked if it's necessary that I be there, that I'd be there.
Okay. So you don't attend doctor's appointments for your child. You don't appear at emergency room when your child is in the emergency room. Is that correct?
Not 100%.
So you have appeared at doctor's appointments and emergency room visits?
I have appeared at a doctor's appointment.
one singular doctor's appointment throughout your child's life?
And I also have stated that I've stated to the court and I've stated to the petitioner that I would attend these upon request, but I don't find it necessary that both parties take the time off of work to go to a doctor's visit. I personally will go to a doctor's visit, but I'm not saying that it's necessary for both parties to lose wages over the situation.
Have you ever offered to take your child to a doctor's appointment so that my client didn't have to lose wages?
Yes.
My client has offered additional time when there have been issues with daycare and babysitter providers to which you've refused. Is that correct?
Say that again.
Okay. My client has offered additional time outside of the parenting plan when she's had babysitter or daycare issues and you have declined those visits. Is that correct?
No.
My client has never offered you additional time and you've never said no.
There's potential that at a particular time it may not have worked out, but it doesn't mean that it's a reoccurring situation.
You've never had Ezekiel overnight.
No.
Arguably, you've never had him over an 8-hour period of time by yourself.
Unfortunately, no.
There were some discussions in your testimony and in my client's with some issues with your visitation with Ezekiel, primarily as it relates to nap times and maintaining his routine. Do you acknowledge the fact that there's issues with his routine while in your care?
There was an issue with Ezekiel abiding to taking a nap to a situation, and I did not impose putting him through an upsetting state given the circumstances.
Are you aware that Ezekiel takes a nap every single day?
I'm aware that Ezekiel takes a nap.
Okay. And you acknowledge the fact that while in your care, he does not take a nap?
These last 2 weekends, yes, that's the circumstance.
Prior to that, he took naps while in your care?
Yes.
Do you know what Ezekiel's schedule is?
The scheduled time that I get him currently, our agreed upon hours is 9 a.m. to 5 p.m.
I'm asking, do you know what Ezekiel's routine is? When I say schedule, I mean routine.
His current routine? No.
So if you were to have him in your care beyond the time that you currently have him in your care, you wouldn't know when he wakes up, when he goes to sleep, when he takes a nap, when he eats, any of those things?
These are all variables.
So is that a yes or a no that you don't know his schedule?
I don't know what his schedule is with Natasha's time. His schedule is not going to 100% abide during my time.
Okay. Do you think it's, for lack of better words, good for a child to have varying schedules in various households?
To my acknowledgement, circumstances being that it's a split household, his routine may be similar and it may be different.
Earlier in this case, you were required to have an alcohol evaluation. Do you recall doing that?
Yep.
And you completed that alcohol evaluation?
Say that last part again.
And you completed that alcohol evaluation?
Yep.
Okay. And the evaluator indicated you were high risk for relapse. Is that correct?
I don't believe so, but if you have documentation that says that I was high risk, then yes.
Okay. We've filed the evaluation with the court previously. Is that correct?
I believe so.
You indicated in your testimony today that you were arrested for a DUI several years ago, correct?
This was also submitted to the courts.
Okay. So I'm just trying to get a history here. You indicated to the court that there's been nothing to substantiate any allegations that my client has that you have a drinking issue. Is that right?
There's nothing currently substantiating the situation.
Okay. But you have a history of alcohol use and abuse.
There's one documented event.
Okay. You testified yourself today that you got a DUI and you checked yourself into treatment for that DUI. Is that correct?
Say that again.
You testified this morning that you were arrested for a DUI and you completed treatment for a deferred sentence for that DUI. Is that correct?
Yes.
Okay. Even after having a DUI, you continued drinking while in a relationship with my client.
No,
You did not drink at all while in a relationship with my client.
I'm an adult and I'm entitled to have a beer at my leisure.
Okay. You heard testimony from my client about a 4th of July incident. Do you deny that that occurred?
Deny what?
That you were blacked out drunk on a 5th of peanut butter whiskey and then proceeded to mix tequila and energy drinks?
I deny the statement.
You deny the statement, but you don't deny that that actually occurred.
I deny it.
Okay. You're still drinking to this day.
Nope.
You didn't acknowledge to my client that you're continuing to drink.
So let's not get this confused. We're talking about excessive drinking comparatively to casual drinking. To me, have a beer is not something that's uncommon amongst people.
Okay.
Now, do I have a beer occasionally? Yes.
So for someone who's been evaluated by an alcohol evaluator, did not recommend treatment, but also indicated you have a high risk for relapse and you're continuing to drink. Is that correct?
So my statement, even during my evaluation, persisted of me saying that I drink a beer occasionally.
Okay. So you still drink. That's your testimony. Do you ever drink while your children are in your care?
No.
Okay. You indicated in your testimony that you left Elijah, who was 8 years old, alone while you went to pick somebody up. Is that correct?
That's true.
And you picked this person up and were at a bar. Isn't that also correct?
Yep. I went and picked them up and just dropped them off and I went back home
And is there a reason why your child couldn't accompany you during this time?
because I wasn't going to impose my child to be around the influence.
Has your children ever seen you intoxicated?
No.
You testified, and you heard my client testify that you historically and or currently use marijuana. Is that correct?
Historically,
Okay. You don't currently use marijuana?
no.
Okay. Have you ever smoked while your children are in your care?
No.
Your children have never been exposed to you being intoxicated on marijuana?
No.
Did you not testify or at least state in the most recent hearing with the request for the hair follicle that you're continuing to use marijuana?
I'm not continuing to use marijuana. At my current employment that I've been at for 4 months now, it's not accepted that I use marijuana at my employment.
Did you not provide your analysis reports for that employment pre-drug screening that had positive for marijuana?
Those were my initial drug screens through the company. And so previously I did use marijuana.
Okay. I want to go back to Ezekiel's care. You're aware that Ezekiel currently sees a speech therapist?
I'm aware.
Okay. And you were notified by my client giving your number to the speech therapist to communicate with you directly. Is that correct?
I acknowledge this.
Okay. And you asked the speech therapist to stop contacting you. Isn't that also correct?
Nope.
And you admonished my client for giving the speech therapist your phone number. Isn't that correct?
The circumstances to the situation was that I told her that not to be just giving my phone number out to anybody and everybody.
Anybody and everybody, meaning your child's care providers.
If it was agreed upon, that would be the necessary attempt.
Wouldn't that also require you to be involved in your child's medical care for that to happen?
And I am involved with it. She has the opportunity to communicate with me.
Did you know your child needed speech therapy before he was enrolled in speech therapy?
It was conversated. That was the circumstance.
Since it's been addressed already that you don't attend medical appointments, how are you aware of what your child's medical needs are?
If it was communicated with me or if I was given the opportunity to go to a medical appointment with him based off of how I previously stated that it's not necessary that both parties take time off of work to go to a doctor's appointment, I would attend the doctor's appointments.
Have you ever contacted his doctor to get an update as to his medical records or care?
No.
Do you even know who his doctor is?
Yes.
Isn't it true that you frequently switch days for your visits with Elijah so that you can work on the weekends?
Elijah,
Or Ezekiel, excuse me.
it's become an opportunity where I asked for it to be the situation, and it worked out in my favor. Yes.
Okay, so you're voluntarily not exercising time with your child so that you can work.
Given the circumstances, I asked for the opportunity and I was granted the opportunity. Yes.
But it's your request today to have additional time than what's currently ordered, yet you're not even exercising that time.
The exercise of time was based off of circumstances. If I was denied the opportunity to switch days with her, then I would have taken the current time.
Okay. Do you have any clothes for Ezekiel at your house?
Yes.
Do you have a bed for him?
Yes.
Have you provided any of that documentation to my client or the courts?
I didn't know it was necessary that I provide documentation of clothes and or a bed.
Okay. Is it true that Ezekiel sleeps in a playpen while in your care and not a bed?
So I have a bed and I have a playpen.
Let's talk about the lifetime of this case. My client filed for the divorce, is that correct?
Correct.
Okay. And I've been involved throughout the entirety of this litigation.
Correct.
There was significant attempts by my office to get you to comply with discovery, is that correct?
I wouldn't necessarily phrase it significant, but there was attempts, yes.
Okay. There were several meetings in my office with me personally, with you, trying to get discovery, is that correct?
I was doing my best to try to get you the paperwork that you would need.
Okay. There were threats for a motion to compel, is that also correct?
There were threats, motion to compel. What does that mean?
There were threats that I would file a motion to compel to get you to comply with discovery if you did not provide me the documentation.
I guess. I
Okay.
tried to do my best.
Sure. I had to subpoena your most recent employment records from your previous employers and your current employer.
Okay.
Okay. You did not attend the mandatory settlement conference.
I unfortunately missed it.
Okay. I made several different attempts between then and now to resolve this case with you. Isn't that also correct?
I also reached out to you.
Okay. At no point, whether it's to the court or to me, have you ever provided your position to finalize this matter?
I wanted the opportunity of the court to hear the situation as a whole instead of it just being shorthanded.
And you understand that with all of those attempts and with forcing this matter to go to trial today, my client has incurred significant attorney's fees.
It's your client's option to have representation to the situation.
Isn't it also true that throughout this entire case, you've never pressed this matter forward to finalization?
Based off of all of the allegations, like I previously stated, that I wanted the court to have the opportunity to see the situation as a whole.
So, but for my client and or her attorney, this matter would never have been finalized. Fair to say?
Say that again?
But for my client and myself, this matter would not have come to trial or be finalized. Isn't that fair to say?
Yeah, it wasn't necessary that it go to this far into going to a trial.
Okay, but you also acknowledge that you failed to participate in any settlement discussions.
Say that again?
You said that it didn't have to come this far to a trial, but you're also acknowledging that you failed to participate in any settlement discussions.
Me and the petitioner had the opportunity to go over things together without having to push further into the courts.
Okay. I'll move on. You've already been ordered by the court to pay attorney fees, is that correct?
Based off of my one missed hearing, yes.
Okay. And you have not paid those to date?
Currently still trying to figure it out.
You were found in contempt earlier on in this case, is that also correct?
I was in contempt
Yes.
for what matter?
Back in February of this year, the court found you in contempt for failing to pay daycare expenses. Does that ring a bell?
And it was I previously stated that in the current circumstances, I wasn't able to afford them, so I was held in contempt. Yes.
Okay, and the court ordered at that hearing that you not only pay arrears for childcare, but also attorney's fees. Do you recall that as well?
Attorney's fees for what?
For having to bring the motion to get you to comply with the court order. Do you recall that?
What? But what was what? The only attorney fees that I'm aware of was this last missed hearing when we were supposed to do the, not mediation, but where we sit down and talk to each about things.
Okay.
I wasn't aware of previous attorney fees.
Okay, so you weren't aware that at that contempt hearing on February 14, 2023, the court ordered you pay $500 in attorney's fees?
I wasn't aware of the $500 attorney fees.
Okay, so at this point, you owe my office $1,500 in attorney's fees for my client's preparation for a contempt motion and a settlement conference to which you were ordered to pay fees. Do you acknowledge that?
Understood.
Okay. Judge, at this time, I'm ready.
Okay. So it's your turn again, Mr. Geis. This is what we'd call your redirect examination of yourself. So if there's additional information you'd like to share, go ahead, please.
So I'd like to look at my most recent pay stub for Great Western Malting. My last pay stub.
Do you have a reference? Do you have a document number that I could look at?
I'm trying to look it up right now. It's not in the paperwork and I didn't file it, so I'm not sure that's going to be something that's going to be able to be used. But my employment with Great Western had variations to my pay, and so in the last few months that I worked for Great Western, so there was a reflection that I made $70,000 gross in the I think 10 months that I worked there. But the circumstances are is that I made substantially more at the beginning of the year towards the end than towards the end of the year because me working for Great Western it's a malting facility. It makes malt for beer. Well, there was an economical change which happened towards the end of the year, which got my hours cut back, which my paychecks working for the company changed drastically, so that it was stated that I chose to leave this job that I made $70,000 that year. At that point in time, when I decided to leave the company, I was only making $1.50 more an hour working for the company than I was making working for the Office 842. Now, it's quite understandable that if it was consistent throughout the whole process that I was making the money that led up to me having an earnings of $70,000, that why would it be necessary that I change employment? But that wasn't the case. And so I wanted to be noted that variations did happen. Things did change. And so I made the most appropriate decision for myself at that time. That's all I have to say.
Okay. All right. Thank you. Recross, Ms. Bliss.
Yes, sir. Just on that one issue, Mr. Geis, I'd like you to turn to what I marked as Exhibit 11.
Okay.
You have that? Okay. So if you look at section number 2, where it says Great Western Malting Company, do you see that?
Yep.
Okay. And on the right-hand column, it says quarter 22.4, 22.3, 22.2, 22.1. Do you see that?
Yep.
Okay. So it was just your testimony that you earned more earlier in the year and tailed off later in the year, and prior to leaving your employment, you were kind of in a lull. Is that accurate to say?
So in the fourth quarter of 22, there was an influx. So I guess the third quarter, not so much, but the fourth quarter, there was a lull in production. And it's 23 right now. 22 was last year. How did I work the fourth quarter of last year? Okay. So yeah, there was, yes, that was the circumstances. There was a lull in production and hours got cut. You can see how um, the previous quarter I made 20,671.55, but then the fourth quarter I made 19,584.15, and it was going to consistently drop because it was, um, to my perspective, about halfway through the year or through that quarter is when things influx started happening. So at that point in time, I wasn't able to, based off of both not having a shared income household and me being able to afford everything on my own. Equivalently, that the influx in pay happened, that I had to make a decision based off of the circumstances. I even communicated with my employer saying that I needed uh, particular opportunities for me to be able to keep my job of employment because I had such um, because I had many things to look forward to be able to stay with the company with all the benefits and stuff like that. I didn't want to leave the company, and at that point in time, I did make the decision based off of what I had to do.
Okay, so you acknowledge that this document indicates that you made $16,301 the first quarter, $15,093 the second quarter, $20,671 the third quarter, and $19,584 the fourth quarter.
This is accurate.
Okay, and then turning to the Office 842, whom you left that job for to go to, you earned $2,424 in the fourth quarter. I'm assuming you had just started your employment late in the quarter, but looking to the 2023 first quarter, you earned $12,348. Is that accurate?
And their accuracy to the situation is that in the quarter is 3 months. And so in 1 month, I was spending $500 a month in gas. And so that's $1,500 difference. And so it does have a slight reflection of that not being 100% logical. The way of the circumstances are is that even upon me losing my vehicle, the Office 842, because I didn't know what the financial disposition was turning into, upon me losing my vehicle because it's a loan, the job was within walking distance of my home.
And
So
one last thing. You worked substantial overtime at Great Western Malting, isn't that also correct?
Okay. At a point in time, yes, I was working substantial overtime.
Okay.
Towards the end of it, no, I wasn't.
Thank you.
What?
Okay, all right. That concludes the testimony of Mr. Geis. Thank you. Mr. Geis, would you like to call additional witnesses?
No.
Okay. All right, thank you. Ms. Bliss, any rebuttal witnesses?
No, Judge, I still rest.
Okay. All right, so that takes us to the end of the presentation of evidence. So now we're at the stage of the proceedings where it's closing arguments. This is where each party has the opportunity to summarize their argument based on the facts presented today and argue why those facts support your position and what you're asking for. So I'll turn the time to Ms. Bliss for closing argument, and then we'll hear from Mr. Geis.
Thank you, Judge. Judge, you've heard testimony from my client and Mr. Geis this morning. I think both parties have provided substantial information to the court regarding obviously the biggest issue of this case, and that's the care of Ezekiel. What you've heard from both parties is that it's been no contest that my client is the primary parent of Ezekiel and has been the entirety of his life. Father's interactions with Ezekiel have been minimal, whether that be by choice or by employment, but there wasn't even a contest as regards to his participation in the care and the upbringing of Ezekiel. You heard testimony from both parties that even in an emergency situation, father refuses to provide care for Ezekiel and fail to even come to the emergency room. You heard testimony from both he and my client that he does not get any information as to Ezekiel's care unless my client provides it. He's never sought out the information upon being contacted by a provider. He said, "Stop contacting me." So that speaks volumes as to his ability and willingness to participate in the care and upbringing of Ezekiel. The information that's been provided to the court, in my opinion, suggests that my client's proposed parenting plan is in Ezekiel's best interest. You've heard from both parties that Ezekiel has never spent substantial time with Mr. Geis, has never spent more than an 8-hour period with him. Obviously, if the court is going to make a determination as to a parenting plan as we move forward, I ask the court to take great consideration to that fact. The fact that Mr. Geis, during the relationship and even after the relationship, primarily put the responsibility on my client, and that is the parent, and not only her testimony, but in his as well. The financials kind of speak for themselves. Mr. Geis acknowledges the fact that his prior employment, prior to this dissolution beginning, he earned substantial income, worked substantial overtime, and then took a job in town with significantly reduced income, earning significantly less. And we argue that was intentional, and that was for purposes of reducing his child support obligation. So for purposes of child support, my client's proposals are taking her actual income and what Mr. Geis should be earning. It's great that he's taken on employment down in Battleground now, making substantially more than he was making with the Office 842, but his behavior speaks volumes. Looking to the asset and debt distribution, I didn't hear anything from Mr. Geis contesting our proposals, so I would ask that those be entered as they've been presented. I believe that those are fair and equitable. I believe my client has provided substantial information to confirm this with the court. And lastly, as it relates to attorney's fees, you heard some substantial testimony not only from my client, but Mr. Geis as to the timeline of this case, who kept pushing the ball closer to the finish line, and that was my client. And she had to bear substantial attorney's fees to that regard. We did provide you a affidavit of attorney's fees for the costs that she has incurred up to date, and presumably through the end of getting this matter finalized. We're looking at nearly $13,000 for a case that arguably could have been resolved straight out of the gate, or additionally at the mandatory settlement conference had Mr. Geis participated. My client is largely a single mother at this point. You've heard that there's been substantial fights to get child support and child care paid by Mr. Geis. So not only is she fronting nearly 100% of the cost to care for Ezekiel, she's fronting 100% of the cost to get this matter finalized. So I ask the court to take that into consideration as well. With that, Judge, that concludes my argument.
All right, thank you. All right, Mr. Geis, closing argument, please.
Pertaining to that last bit of it, it's not 100% true to say that Natasha's fronting the bill on all of this when my contributions are being paid. You know, it's not like I'm still haven't paid anything towards child support and she's completely footing the bill. I understand what child support is supposed to be for and what child care is what it's supposed to be for, but I want that to be taken in consideration that my contributions are involved, and that based off of the way that the case has been moving forward, there's been some steps forward and steps back throughout this whole process. And what it comes down to is agreeing or disagreeing upon things. And so at several points in this process, it's been addressed to me that I just need to sign it the way that it is. And because I don't agree to the way that it is, now it's going to continue forward, because I can't just agree to something that I don't agree to in the matter. As far as Ezekiel and my opportunities with him, I've been limited to being able to have time with him, and I would be grateful to be granted more opportunity and time with him, because that at that point in time, it would be alleviating responsibility off of Natasha, and would also give me the opportunity to developmentally progress with Ezekiel in both my own personal maternal level, educational level, doctor's visits, or anything else along those lines. That it's a lot more common nowadays that fathers are granted more time with the children comparatively how it was in the past. And I would like the same kind of courtesy to be able to give Ezekiel the most of an opportunity that he can have. And all things considered, I think that's really what my closing statement has to be.
Okay. All right, thank you, Mr. Geis. All right, so just taking a look at the time frame, we're a little bit after 11:30. I have a meeting that'll run for about an hour and a half, starting at noon. So I want to take more than just 25 minutes to review my notes and look at the exhibits and the like. So what I'm proposing, if the parties would be available I don't know if you're available today at 3 p.m. to come back on the Zoom call at 3 p.m. and I could give you my decision at that time. So just want to touch base with the parties to see if that's a workable hour. Ms. Bliss?
Yes, sir, that works for me.
Okay. And Mr. Geis, how does that look?
Yes, sir.
Okay. All right. So we will use the same link that we used to conduct the proceedings this morning, and we'll reconvene today at 3 p.m. and I'll give you my decision on the issues presented at that time. So before leaving, just thanks to all the parties. I appreciate the manner in which you all conducted yourselves today. Going through this is not an easy process. It's hard, it's challenging, and I just appreciate the way that each of you conducted yourselves. So thank you. So I'll go ahead and sign off, and then we will reconvene at 3 p.m. this afternoon. Thanks. Okay, welcome everybody. Thanks for your punctuality and thanks for the patience and allowing me a little bit of time to gather my thoughts and share my ruling. So with regard, I'll just jump right in. So with regard to the debt distribution, there was information presented by Ms. Geis related to the debts, the varying debts and the varying assets as of the date of separation. None of those were contested. They were supported by bank statements and the like. And so I'm going to go ahead and adopt those as presented. And so specifically, so everybody knows where we're at, the Silverado obviously stays with Mr. Geis, the Chevy. The Red Canoe savings account ending in 746 that has a balance of $5 that goes to Mr. Geis. The Red Canoe checking account ending in 746 with a balance of roughly $310 goes to Mr. Geis. The pension or 401k through the Teamsters or what have you, that goes to Mr. Geis also. As far as property for Ms. Geis, the Hyundai stays with her. The Red Canoe checking ending in 02705. Canoe savings account ending in 746 that has a balance of $5 that goes to Mr. Geis. The Red Canoe checking account ending in 746 with a balance of roughly $310 goes to Mr. Geis. The pension or 401k through the Teamsters or what have you, that goes to Mr. Geis also. As far as property for Ms. Geis, the Hyundai stays with her. The Red Canoe checking ending in 02705 goes to her. The fiber account, which is divided in two, one's checking and one savings, ending in 0922. Checking's in the amount of 1,018. Savings is in the amount of 1,005. Those will each go to Ms. Geis. And I just saw Mr. Geis adjusting your earpiece. Have you been able to hear what I've been saying?
Yes.
Okay, great. All right, very good. So when you add up those balances, that sets Mr. Geis's property balance at roughly $33,230, and that sets Ms. Geis's balance at roughly $29,547. As far as the debts, the debt associated with the pickup, the Silverado, that goes to Mr. Geis. He'll be responsible for that. The upgrade credit card as of the date of separation, that's the account ending in 8191. And the amount of $1,903 will be assigned to Ms. Geis, comes up with a shortfall of $14,767. So I'm adopting the balance sheet as presented by Ms. Bliss. Before I go further,
Pardon me.
yes,
Pardon me, sir. What does that mean?
That's basically assigning the values of the debts as of the date of separation. So each party is responsible for those debts, and they're divided up. So if there's any question whether it's Mr. Geis's or Ms. Geis's or the community's or somebody else's, I've assigned who's responsible for those particular debts. Does that help?
Yes, sir.
So let me just jump right into the parenting plan. With regard to the parenting plan, here we have a child, Ezekiel. Zeke, as it sounds like he's often called, is now 2 years old, and it seemed to me that there was a fairly clear division of responsibility within the family between Mr. and Ms. Geis. Mr. Geis was in charge of principally financial responsibility. He was working long hours, 12-hour days with about a 2-hour commute to and from work. So a lot of the burden of caring for little Ezekiel fell upon Ms. Geis. And I definitely agree with the proposition that when we have a child who has both parents that's actively involved in their family, actively involved in their life, that's obviously in the best interest, barring any other factors, in the best interest of the children, to have those two involved parents. So what I saw from the evidence that was presented today is that Ms. Geis has shown significant and steady dedication to Ezekiel by the giving of her time and energies. directly. And Mr. Geis also has shown his dedication by working to supply income to meet the needs of the child. And I also find it's important to note that children obviously are multifaceted individuals. They need physical needs. They need their emotional needs met. So they need more than each parent roughly. In that their income earners should be in a place, even though it's a challenge when you're working long hours, to give more of themselves, maybe emotionally and with time and the like. And I think that the evidence that showed there was more of a narrow focus for Mr. Geis as far as the financial support. He's very focused on that, and not improperly so. And however, that came at the detriment of providing more of the actual hands-on physical needs and also the emotional needs of Ezekiel. And the evidence pointed out that the medical appointments were kind of a telltale sign of that, where Ms. Geis was the one who went to those appointments. And that was, that's a form and function of the division of responsibility within the family, is that Mr. Geis felt it was very important that one of the parents continued to work while the other one took the child to the appointment. And it sounds like Ms. Geis attended all of those. Mr. Geis attended one of those. Also, I think the emergency room visit, well, obviously that's a very distressing event when a child falls. That Ms. Geis was the one that went and took the child, obviously because she was with the child. However, when Mr. Geis was given the opportunity to come and be there, not only maybe just an emotional support to the child, but to be present and be eyes and ears and hear what the doctors and medical professionals are saying or talking, and kind of coming to his own conclusions, and not necessarily delegating that responsibility out. I think that kind of shows where the parties are at mentally as far as caring for the needs of the child. So I think that what that tells me is that there is a request for a finding of neglect. I'm going to make that finding as to Mr. Geis. I think that is supportive of that. Related to the communication here, I think the communication is very strained between the parties. Mr. Geis has indicated that he prefers email communication because that everything's documented, and the Family Wizard app, or the app that was mentioned earlier in the testimony, is cost prohibitive. Therefore, he opted for the email. And again, here when there was information related to the well-being of the child, it sounded like the child caregiver made contact with Mr. Geis, and Mr. Geis indicated that he doesn't like to be yelled at, and so he wasn't going to do that, and so that the communication then was through text during that time. So what that tells me is that there's some pretty significant difficulties of the party communicating, even in times of emergency. So I think it's in the best interest that when the child has emergent medical needs, that sole decision making is given to Ms. Geis. So as to medical, I'm giving sole decision making as to the child, to Ms. Geis. Education at this point, child's 2 years old. Pretty hard to say what's going to happen in the future. So as far as education, I think education tends to be maybe a slower moving target. And so therefore I'm going to make that joint decision making between the two parties. And I'm just going to make just one quick note to myself.
Pardon me.
Yes, sir.
So you found it right that the opt for neglect was suitable based off of my not attending doctor's appointments?
That was one of the factors, correct?
Okay.
So therefore, regarding there were concerns related to alcohol and drug abuse. I heard information that Mr. Geis had a DUI and went through a deferred prosecution, or is still involved in a deferred prosecution, not quite sure of the status, but had an evaluation related to that. So I know that sometimes when a judge is giving a ruling, there's desires to fill in gaps. The opportunity to fill in those gaps has passed, because when each party rested, that marked the end of the giving or presenting of testimony. So I'm basing my decision based on the evidence that was elicited and given during the trial. So while I may not know the specifics, I think I have a fairly good idea of what was related to at least the DUI. There was a DUI, it happened, there was a citation, deferred prosecution happened, and that Mr. Geis indicated they went to treatment and the like. I also know that there was an evaluation conducted that indicated that recommended no treatment, and also indicated that there's a high risk for relapse. So with that, the parties have been using a fairly limited schedule of visitation, where Ms. Geis is the primary custodial parent and Mr. Geis has visitation or residential time each weekend for a period of 8 hours continuous on either Saturday or Sunday. So here, I don't see any reason to disrupt the pattern where Ms. Geis is the primary residential parent. I think the parties have made that decision themselves previously, and I think the evidence presented at trial bears that out and supports that. Here, I think it's Mr. Geis has indicated that he wants to have more time with his child. I think that's important, and I recognize that. And I think all parties recognize that having two parents involved is very, very, very important for the well-being and best development of Ezekiel. So, and I also recognize also that there has not been, since the child was roughly 4 months old, that there has not been any overnights of the child with Mr. Geis. So I think there's some prudence in moving somewhat slowly and not necessarily jumping up to a real jump up in visitation. So what I'm going to do, I'm going to keep the every Saturday from 9 to 5 p.m. and then on the Sunday following from the same time, and then we're reverting back to the Saturday, Sunday alternating each week, and that'll continue until age 4. At age 4, then the overnight can begin where on Saturday at 9 a.m. until Sunday at noon, and then that will be on the first, third, and fifth weekends. And then Mr. Geis will have an every midweek visit, Wednesday from 4 to 7 p.m. And I'm not beholden to the Wednesday. If, schedules need to be adjusted, if the parties agree in writing, then that can be adjusted to a different date. But that's the court's intent, is that there's weekly, midweek contact between Mr. Geis and his child. So
just because
Yeah.
sir, just because I want to be able to write this stuff down, can you repeat that scheduling that you're ruling on?
Yeah, absolutely. Absolutely. So there'll be a continuation of the current parenting plan of weekly visits for 8 hours on the weekend, either Saturday or Sunday, 9 to 5. And then at age 4, then this the visitation will be Saturday morning. Mr. Geis's residential time starts at 9 a.m. It will extend overnight until Sunday at noon. And that will occur on the first, third, and fifth weekend of each month, as defined by Fridays. And then every Wednesday, so every Wednesday of every week, there'll be visitation from 4 p.m. until 7 p.m.
Every Wednesday?
Wednesday, correct. And if that interferes with scheduling, one party, I work till 6 on Wednesday, can we move it to a Thursday or to a Tuesday? As long as the parties agree in writing, that's great. If you can't agree in writing, then the default applies Wednesday, 4 to 7.
4 to 7.
Right.
And then the Saturday to Sunday is starting at 4, the first Sunday of what? Or the first Saturday of what?
Yeah, that occurs when the child turns age 4. So when the child turns age 4, then the next Saturday, if it's the first, third, or fifth weekend, then it'd be Saturday at 9 a.m. until Sunday at noon.
And I don't mean to speak out of turn, but Mr. Geis, you will also receive, once I prepare, this is an oral ruling, and then I prepare physical orders to the effect, so you'll receive those as well. So don't be concerned about making sure everything's written down. Sorry, Judge.
Yeah, it's good, and I appreciate that the summary will be forthcoming, and that Mr. Geis has an opportunity to write it down right now from the horse's mouth, if you will. Okay. Then I also wanted to make mention related to, there was a request for an alcohol or marijuana restriction, basically no consumption of either of those substances 12 hours prior or during the residential time of Mr. Geis. I think that's warranted. Here, the testimony has showed that there had been an issue related to alcohol connected to the DUI. There was some evidence related to the July 4th incident about excessive drinking. And then there's concern for the high risk of relapse and continued consumption of beer, as Mr. Geis had indicated. So I will apply that restriction as presented. I think that's appropriate. Then I wanted to double check with one thing with the parties. On the proposed order, there was a request that Mr. Geis be evaluated for substance use disorder with collateral input from the parties. And I know that there was an evaluation that was done in the not too recent past. I don't know how far in the past it was. And so I just need a little input from the parties. Mr. Geis, do you remember when that evaluation took place?
We separated in March of 22. The evaluation might have taken place in around October of 22.
Okay, so just slightly over a year ago.
I believe so.
Okay, and then Ms. Bliss, do you know if there was collateral input from petitioner or any GAL?
There was, Your Honor, and upon reviewing my proposed parenting plan, I think that was just simply left in from the proposed parenting plan and it was inadvertently left in, so I would ask to have that removed at this point since he's already completed that.
Okay, yeah, that should be omitted from the parenting plan, so I'll strike that. One moment. Okay, thanks for addressing that issue with me. Let's turn now to child support. I think that Ms. Geis's income is fairly straightforward, pretty easy to determine based on the pay stubs that were presented. She earns a gross of $37.59. she has a net of roughly $2,736. So there was some concern expressed by Ms. Geis related to Mr. Geis possibly taking a lower paying job. I took a look at the employment security data, and what it showed me is that Mr. Geis has a fairly consistent pattern of frequent job changes. I think we go back roughly 7 years, back to 2016, he's had 13 different jobs. So that's roughly 2 jobs per year. So he has a pattern of changing jobs, so it doesn't seem like that's unusual that he would change his job, other than at Great Western, he was making more money than I think he had made in any other employment security data reported job. So he indicated, Mr. Geis indicated that he indicated that the cost of the gas to the commute was significant and was a factor in his job switch. Maybe not so much the distance, Battleground, Vancouver, the like. And he indicated that taking into account the cost savings of not paying gas, maybe even wear and tear on a vehicle, resulted in roughly a net difference of $1.50 an hour between the 2 jobs. However, when I look at the Great Western employment security data, Mr. Geis had indicated that there was a slowdown at the end of the year, and he was earning significantly less, and that was kind of motivation of, the malt industry didn't need as much malt, and so things were slowing down. He wasn't getting the hours. The numbers indicate otherwise. They show roughly that there was a dip in the fourth quarter, but by roughly about $1,000 over that quarterly period. So not a huge amount, but fairly high wages at that point still. So that showed me that there was roughly an average of $42 an hour for the 10 months that he was working there, versus the $25 an hour that he started earning at Office 842. So that gives some traction to the argument by Ms. Bliss's client that Mr. Geis had changed the jobs to potentially lower his child support obligation. And I note that at prior to Great Western, he wasn't earning as much as he was at Great Western. That was a good paying job. And now he's making a wage that's more historically in line and more reasonable with what he had previously made, although it appears to be slightly higher at that $30 an hour. So that's the figure I'm going to use. I'm not going to impute him at the higher Great Western wage. I'm not going to do that. I'm going to use his current wage of $30 an hour with all the tax withholdings and the like removed. And so that's what his hourly, his net income should be based on. I will apply the whole family deviation, as Mr. Geis is supporting Elijah, his other son. So that whole family deviation should also apply. So let me just double check that. I think the next item is attorney fees. Here there's a request for attorney fees from Ms. Geis, and her argument is that she's the one that's been pushing this case along, and if but for her pushing, this case would not be at trial and would be very difficult to resolve. And that has some merit to it, in that the evidence has shown is that there's been some resistance by Mr. Geis as far as participating in discovery. There was a finding of contempt related to that, and also a non-participation in a mandatory settlement conference, which is a great off-ramp. If the parties can come together and potentially work on, maybe not all the issues are resolved, but at least maybe some of them can be resolved, and there was non-participation there. Also, I think a telltale sign of resistance is the fact that subpoenas had to be issued for employment records. Employment records generally can be obtained by the employee or the former employee by a mere request of that individual and then turned over. But here there was an added step that was required. So I think that there's those two bits of evidence that I look at, is that there, but for the involvement of Ms. Bliss and her familiarity with the system to push cases along and get cases resolved, and the indication that Mr. Geis was somewhat resistive to the process itself with specific examples, I'll award attorney fees of $5,000. It's not quite an equal split, but it's a little more, it's less for Mr. Geis than it is for Ms. Geis. So that's the court's orders. So I'll ask any party if you have any questions or clarifications related to the court's ruling.
Yes, Judge, just a clarification, when you were discussing the, I'm assuming you were in the parent plan at the section 3B, you started talking about some Mr. Geis's alcohol history, the DUI evaluation, and then we kind of trailed off into the residential schedule. I wasn't sure if you were making a finding of substance abuse within that section.
I'm not. I'm striking substance abuse finding. I'm not making that finding. I think there's concerns that are manifested by the restriction on consumption before and during, but I'm not making that finding.
Okay, very good. The issue of the tax exemption, we had made that request.
Yeah, thank you. I appreciate that. With regard to the tax exemption, let me pull up my note on that. So this is in the proposed child support paragraph 19. the argument from Ms. Geis is that there's a shortfall based on childcare and the like. Mr. Geis is also, and also Ms. Geis is, with the child a significantly larger period of time. So there's an argument that there's maybe greater resources being spent to care for the child. Mr. Geis indicates that, hey, I'm also paying child support that's supporting this child. So I'm going to make it equitable. In odd years, Ms. Geis has the right to claim Ezekiel. In even years, even tax years, Mr. Geis has the right to claim Ezekiel. And that should be conditioned upon Mr. Geis being current in his child support for that even year, tax year, by the January 31st of the year following. So let's say, 2024, if Mr. Geis has paid all of his child support for 2024, and we know that by January 31st of 2025, then Mr. Geis can go to his 2024 tax return and claim Ezekiel for the tax year 2024. So that should be included in the order.
Very good. That's
Pardon me.
Okay.
Mr.
Geis.
So I'm able to claim him on odd or even years,
You will
providing
be
conditions.
You will be even. You'll be even years. Ms. Geis will be odd years. So 2023 will be Ms. Geis. Ms. Geis's opportunity in 2024 will be yours, and then I'll just flip flop thereafter.
Okay.
Any other points of clarification? Those are very helpful questions. Thank you. If not, there's a couple of orders that probably need to be modified slightly, that Ms. Bliss will prepare, and she will forward a copy to you, Mr. Geis, of those changes that the court ordered here today. And then if you have objections to those, or meaning that the court didn't order that, or Ms. Bliss interpreted that incorrectly, then we'll set a presentation date so you can present those objections. So let's take a look at the calendar.
I can make January 5th.
Okay. Mr. Geis, does your schedule allow on Friday, January 5th at 8:45 to have a hearing related to the proposed orders based on today's ruling?
Friday, January 5th, at what time?
8:45 a.m.
I will be there for that.
Okay, and that also will be via Zoom, so parties can participate via Zoom in that manner. All right, so we'll go ahead and schedule that. I'll double check with Madam Clerk if you have any loose ends that need to be tied up. Okay.
Pardon me.
Oh, I was just asking the clerk if she had any loose ends that need to be tied up. Hearing none, Ms. Bliss.
Again, don't want to speak out of turn, but typically the clerk asks if I want my exhibits back or destroyed. So I'll just say that if maybe she just couldn't get back on, I don't mind if they're destroyed. I would just ask my binder to be returned.
Okay. All right. Thank you. Mr. Geis, any last points of clarification or questions?
Not necessarily. I appreciate the opportunity to work with you on this, and it's unfortunate that things have played out the way that they have, but I appreciate you in the matter.
Thank you. Good luck to all the parties. Good luck in your efforts to raise your boy. Thank you very much.
Thank you.